Okay, so this is what I learned this week in property class. First, a review. The basic idea that the meaning of property is connected to the society and time. And of course, society changes over time. It can be an object, but it is the relationship with respect to that object that is important. Mainly because property can be intangible, so it is not strictly an object. It is the relationship between the parties, one of whom has rights according to that object, or perhaps both. That's important. The rights in this relationship are decided by society through the courts and the legislature. And when property exists, it is a social, political question that some people feel should be answered by the courts and others by the legislature. And also when the facts change, it's controversial. And that's what we see in the Victoria Park case. So today I'm going to be talking about the Victoria Park case, the INS case, direct and indirect limits and extensions of property, the Stewart case, and the Moore case. First, the Victoria Park case dealt with issues of nuisance, which typically came from an agrarian society, and they were used to stop people from having smoke drift onto the real property, the land of someone else, or noise, or but it was really used to stop the interference of someone with your real property. Now, in this case, if it is nuisance, there are some interesting consequences, because how could describing what you see be nuisance? Would that mean that no one could describe anything they see? A nuisance is also just from the adjacent property, so it would only apply to people on adjacent properties being able to describe what they see on the neighboring property. Privacy is to protect your, I'm not exactly sure why we have privacy, but I know it is limited. I'll get to the limitations in a second, but if the privacy law applied here, then you wouldn't be able to watch from anywhere. So it wouldn't just be the adjacent property, it would be anywhere you were standing, up the hill, overlooking the fence, wherever you were. If you were watching and it was declared a privacy issue due to the Victoria Park case, then there would be unintended consequences. And lastly, quasi-property. So this would be saying that spectacle is property and excluding just the adjacent property owner, or just the person who's describing it and broadcasting it. So not actually declaring it property, but limiting the rights of the adjacent property owners. The issue here is, though, that there's very few precedents associated with the race course as property. So it's important to take a look at what the judges said. Now we start with Latham, who argued for the defendant, and he took a very narrow approach, I would say, a positivistic approach. He basically said that there's no precedent, it doesn't fit in with, it doesn't fit in the law, and I'm not going to stretch the law to fit the facts. He said there's no interference with the real property or the people that are enjoying it. He says that there are gaps in the law and the precedents, but he's very concerned about infringing on the rights of other people by moving this law forward. He cites the example of Rylands and Fletcher, or rather, that example is cited by the plaintiff in this case, and he rejects it as ridiculous. the analogy of water flooding a mine has no bearing on radio waves flooding the real property. So he's very focused on the injury to the real property. That's what nuisance and privacy is all about, or nuisance rather. And there's no other laws, so how are the radio waves damaging? With regards to privacy, he sees extending privacy rights of landowners to exclude certain people from watching as having injurious consequences for the general public. He says there's no authority in this case in English law and leaves it at that. The next person speaking for or judging on behalf of the defendant is Dixon. Now, he's very honest and sympathetic. He simply states that, I understand he's losing money, but there's no legal cause of action, and I'm not going to sit here and throw the law a tort. That's not my job. So, similar to Brandeis in INS, which we'll get to, he's an English judge in a Commonwealth country, and this is what the law covers. So, the only precedent for quasi-property came from the US, and he said, there's no law, I'm done. And McDergrand for the defendant didn't add very much. Getting to the judges speaking for the plaintiff, Rich was willing to stretch the law of nuisance to include this infringement on their competition rights. So he stated that there are only classifications of various kinds of nuisance, and that the classifications can be broadened. And the justification he uses for this is that the work, labor, and effort of the plaintiff should be respected. He also says that we can't let this injustice continue, and if the legislatures don't like it, then they can pass an act. So let's not let this injury continue. Justice Evatt agrees with Rich. He says it's a grotesque and unreasonable use of the land, and he is an employment lawyer, so he did know of some cases where the right to watch or the right to look wherever you want to look was restricted in cases of striking workers watching their former place of work. So this is an example of frame shifting. Because of his experience as a labor lawyer, he was able to kind of expand and see things from a different point of view. So those were the judges, and the lawyer for the plaintiff in this case, the only precedent he could find to create quasi-property as an argument and perhaps get an extension of rights for his client was the INS International News Service and versus Associated Press. So in this case, the rights of Associated Press were expanded, though there was no statute declaring property in the news. So the majority justification was that the Associated Press is entitled to their labor, and more importantly, if INS causes AP to lose money, they won't be able to produce the news. So that was their concern, and because of that, they were able to expand the rights and create some quasi-property rights for AP. Judge Brandeis, in the dissent, and the teacher says this is a classic case of frame shifting, says that society is complex, and it is completely reasonable stated that perhaps the legislature should be making this decision. So he was concerned that expanding the rights of AP, the rights to their news as property, would unduly infringe on the rights of the general public to say ideas. He said that once the news is in the air, it's free as the air, and anyone can use it as they wish. So we see some connection between Brandeis and Latham. It's worth noting that the teacher loves this case and thought it should be in the case book because the legal reason is so well articulated. She cites Brandeis often. So now we look at the direct limitations and extensions of property right versus the indirect ones. Direct limitations and extensions are brought through statute. The legislature creates laws that declare things as property and as such extends the rights of the people who have that property. The examples are trademark, copyrights, and patents. And these statutes emerged in the 1800s, though it's worth noting that the courts had to deal with it first before the legislature got involved. Now the indirect limitations and extensions come through the courts, and the examples she cited are unfair competition, confidential information, trust and fiduciary duty, and contract. So you don't necessarily have a property right in your competition, you don't necessarily have a property right in your information or a property right in fiduciary trust. I'm unclear exactly what fiduciary trust is. However, you do have some rights to exclude others. These are quasi-property rights. They are indirect limitations of the general public to infringe on your rights. And the examples she cites are an insurance company where a person who worked for the insurance company left the insurance company and then called up all the clients and said, oh, I left, you should come with me. And that is unfair, actually it's an infringement on their confidential information rights. Desney versus Wilder. Desney created a terrific movie plot and sent it to a movie producer, Wilder. Wilder took the basic storyline, made a bunch of money, and in the court case, they cooked up a notion that there was a contract between the two in order to close the gap in the property rights at the time. Black Minerals, there was a little mining company that found an incredibly valuable gold mine. But they didn't have the means to extract the gold, so they contacted a large gold mine and they cut them out. They found the gold mine, they extracted much of the wealth. By the time it got to the Supreme Court of Canada, they felt that there was a trust and fiduciary duty on the part of the larger mining company. And so they gave the mine to the little mining company. And this was the first case that created trust and fiduciary duty, and it created a quasi-property right. INS is the same thing. There is a quasi-property in the news. So R versus Stewart. So this is, again, we're talking about property rights, but this is a criminal case and it's in Canada. Now, criminal law generally deals more with a concern about the general public and societal well-being, as opposed to civil law, which deals with the conflict between two parties. Though there are punitive damages in civil law that do concern themselves with the deterrence of harmful behavior. So in this case, they find that learning confidential information, then using it once you leave your job is wrong. If it's property for civil law, then it's also property for criminal. And why is that? Because it was gathered with effort and time for the purpose of commercial interests. The dissent in this case thought that they shouldn't create quasi-property rights for confidential information. They thought that if we're going to expand property rights, it should be for Parliament to decide. The dissent continues. It appears that the protection afforded to confidential information in most civil cases arises from an obligation of good faith or fiduciary relationship, more from that than proprietary interest. No Canadian court has so far conclusively decided that confidential information is property, with all civil consequences that such a finding would entail. The case law is therefore little assistance to us in the present case. So the civil consequences of finding property in confidential information is that, actually they discuss that next. Anyway, how do you define confidential information? And who defines confidential information? So what is the precise definition of confidential information? Is confidentiality based on the alleged owner's interest? So they're saying that there are difficulties in expanding these rights, and if it has to be property, it has to be directly property, in other words, created property by statute, and it shouldn't become property as a way to mediate between two parties. So, as I mentioned, they were concerned about the greater picture, that is frame shifting. Indeed, the realm of information must be approached in a comprehensive way, taking into account the competing interests in the free flow of information and in one's right to confidentiality, or again, one's economic interests in certain kinds of information. So you have some rights to confidentiality and economic interests, but we need to weigh those with the free flow of information in a comprehensive way, and the legislature should do that. In the Moore case, it dealt with cell linings taken from the spleen of a leukemia patient without the patient's knowledge for the use in research and commercial interests. So is there property in the body? In order to argue conversion, the plaintiff must have ownership interest in whatever was taken. The defendant must wrongfully take the property right, and there must be damages. Only the middle court in this case agreed that there was conversion in this case. So the plaintiff had an ownership interest in their cell lines, the defendant wrongfully took them, and there was damages because they used the cell lines to, they were worth apparently $3 million with whatever they did create with them. So the Supreme Court of Canada said that no court has decided that you can argue conversion for this type of property, and thus it cannot be conversion. So no one has argued that cell lines are property, thus conversion is ridiculous. They did, however, agree with the informed consent issue. And their justification is interesting. They said the spleen is something that maybe you control, but once it's out of your body, there are lots of regulations, limitations, etc. on body parts that are now out of the body, and there aren't many property rights left. They're also concerned that if you can own a part of the body, you can sell a part of the body, and they didn't want to encourage that. They said if you call it conversion, it has to be property. That's a huge leap, and we don't want to do that. And finally, they concluded this is too much, and the legislators should look after this. And that's what I learned this week in property.